Good evening. This is Deusdeddy Merced. Today is Thursday, March 9th, 2017. This webinar is being recorded. I must review, as I always do, a few important items before we get started. First, an affirmation form was included in the email I sent you with the training outline. At various times throughout the webinar, there will be various codes displayed on the screen. These codes will come in the form of numbers, a combination of words, or both. You must write down the codes on the affirmation form. The codes will not be read out loud. I repeat, the codes will not be read out loud. The course code is now going to be displayed on your screen. So Mark, advance to the next slide, please.
Okay. Oh dear, it didn't do that. Oh, okay.
There you go. Perfect. The course code is now being displayed on your screen. Please write the course code number on the affirmation form. I will leave the course code number on the screen until we finish these opening remarks. Submission of the affirmation form with the correct codes is required by the New York CLE Board and by NYSED for continued certification as a hearing officer. Please keep in mind that only IHOs who participate in the entire webinar session would meet the training requirement and are eligible for CLE units. CLE credit will not be awarded, and the training team cannot attest to your participation unless the codes submitted on the affirmation form are correct and you viewed the live program for the full 2 hours. Partial participation will not be accepted. GoToWebinar tracks the time a participant signed on and off to view the program. I must receive the affirmation form by no later than Friday, March 17th, 2017. Again, that date is Friday, March 17th, 2017. That's a week from tomorrow. Affirmation forms received after this date will not be considered for CLE credit, and NYSED will be informed that you have not met the training requirement. Second, all participants are muted throughout the duration of the webinar. It is our purpose today to answer as many questions and to receive as many comments as time allows. Should a question or comment come to mind during the presentation, we ask that you share either the question or comment using the control panel that popped up when you logged in to GoToWebinar. In that control panel, there's a question dialog box with the wording "Type questions here." We will pause to take questions or comments throughout the 2 hours as time permits. Finally, as I indicated in my email attaching the webinar materials, at the conclusion of the broadcast, a window will pop up that will give you the option to submit feedback through GoToWebinar. Please take a minute or so to fill out that feedback form. All that feedback is sent directly to me, and I will be able to look at it and read and get your impressions of tonight's program. With this, allow me to formally introduce our newest member of the training team. Professor Mark Weber is a professor at DePaul University College of Law. His professional interests are disability rights and complex tort litigation. He is the author of Disability Harassment, Understanding Disability Law, Special Education Law Cases and Material, and Special Education Law and Litigation Treatise. He frequently speaks on disability law issues at national and international programs. He has presented testimony on the implementation of the ADA to the U.S. Civil Rights Commission, and is active in community service and legislative initiatives on disability matters. He began his career as a staff attorney at the Legal Assistance Foundation of Chicago and then worked as a clinical fellow at University of Chicago Law School. At DePaul, he has served as an associate dean and acting dean of the College of Law. He has received the College of Law Outstanding Teaching Award, the DePaul University Excellence in Public Service Award, the College of Law Excellence in Scholarship Award, the DePaul Spirit of Inquiry Award, and the Center for Disability and Elder Law Distinguished Service Award. He has been named the Vincent DePaul Professor of Law in 2004. With that, I welcome Mark to our team, and I hope that you will enjoy him as much as Lynn and I have enjoyed listening to him in past trainings that we've done together in other states. Mark, it's all yours.
Well, great. Thank you very much, DSCD. Thanks for the introduction, and it's quite an honor to be here and to be talking with all of the impartial hearing officers in New York. I guess I should say a word or two before I begin about the selection of materials that I'm going to be presenting today. What I tried to do was to include all Second Circuit cases, at least those with precedential value, and a few even of the unreported cases since the last major update training, which takes you back to around 2015. I've then tried to include as well quite a number of district court and a few state court opinions. And the selection on those is a selection, so it's not as though I've tried to get every single case. It's rather what I've tried to do is get those that I thought were in some respect newsworthy, and then made a further selection or culling for the cases that are on the PowerPoint and that I'll be talking about this evening. Obviously, there's other cases on the larger set of materials, and if you do have questions and would like to inquire about those, you can use the method of dialogue that Deostedi was talking about a moment ago. But I think that probably the ones that are of the most significance in terms of what it is you might want to know for your own decision making are the ones that I've tried to pick out for the PowerPoint. I've also included, in addition to cases, at least a few of the letters from Office of Special Education Programs or Office for Civil Rights, where once again it appears that what the material covered was directly pertinent to things that you might need to know in making decisions in actual cases. So with that in mind, then, what I'd like to do is just begin with the various topics that are on the PowerPoint. So we begin with child find, and with that, the whole cluster of things that include evaluation, eligibility, independent educational evaluation. Child find, there's I think, rather significant case, the RE case that you see in the outline. The reason that I thought it was significant is that there's been an ongoing debate back and forth among courts and a few other decision-making sources about just what it is you do with a child who is performing up to expectations, has a disability, and it appears, at least arguable, that the reason the child's doing well is that the child's getting a lot in the way of supports. Is that kid somebody who's actually eligible for special ed, or because the kid is getting those supports outside of the formal special ed system, is that a kid who, however much that kid might have the disability, doesn't need special education and related services? The RE case is confronting a particular situation where it appears to be endorsing that second idea, where the court is saying, well, the kid's doing well with the Section 504 plan, therefore we don't think the child is necessarily eligible for special education. The parents say, well, the 504 plan is something that looks to us like special education, and so the issue is joined there. A reason that I picked the case out, this will take us all the way to the end of the presentation, is that there are cases from elsewhere in the country that go very much in the other direction, particularly one rather prominent one from the Ninth Circuit. But in any event, I thought that it was important for you all to have access to this RE case. At the same time, I thought that I would put in the Dear Colleague letter regarding child find having to do with virtual schools, virtual charter schools. What's in the outline on that, what's in the materials, pretty much just parrots what's in the Dear Colleague letter itself, and it's a warning to make sure that in a virtual charter school you look out for kids with disabilities, even though there isn't a lot of face-to-face contact in that kind of situation. So those are two cases or two bits of material with regard to child find. Let me turn to things that have to do directly with evaluation and eligibility. The BC against Mount Vernon case is, I think, pretty significant, partly because it's a full-fledged Second Circuit opinion and it's quite recent. It's also one where the school district prevails. It may not seem particularly relevant to what you all do, however, because it's a class action type. I don't know whether it actually was certified as a class action, but in any event, a disparate impact ADA Section 504 claim. So it starts to diverge rather severely from what you would be worrying about with regard to eligibility for IDEA. The reason that I brought it in was that the theory of the plaintiffs was that they could bring in statistics with regard to IDEA eligibility to try to show impacts with regard to Section 504 and the ADA. And the Second Circuit rather resoundingly says, no, you can't do that because IDEA and Section 504 eligibility are two quite different things. I'm not sure they're actually getting that fully correct because under the 2008 ADA amendments, ADA Section 504 eligibility was greatly broadened. Nevertheless, it's probably of significance to you all because if you do wind up with an eligibility case and the parents are arguing or the school district is arguing something about Section 504 or the ADA, you may need to be aware of what the Second Circuit has said about the relationship there. Moving on to the next few cases that deal with evaluation and eligibility, this AW case I think is pretty interesting. The Department of Ed, the Federal Department of Ed, has always said the fact that the kid is passing from grade to grade or even getting good grades or anything like that doesn't necessarily mean the child is not eligible for special education. Nevertheless, you can find plenty of opinions where either a hearing officer or court relies on the fact that the child is doing well in school and, of course, the fact that the definitions of disability, generally speaking, say it is in need of special education. In fact, universally say that. It does raise the question of what if the kid appears to be doing well but still has deficiencies, is the kid eligible? The AW case seems to say, yeah, you can have eligibility, even though in this case the child was doing well on various standardized tests, and it really was because of behavior difficulties and what the court characterized as functional impairments. I think that needs to be taken seriously. The kid did obviously have some other diagnosable problems, had ADHD, had dyslexia, had difficulties with preparation and focus, and it is true that kids with those conditions often can do quite well for a limited period on a standardized test, but still be in need of supports. This is, I think, an interesting case that illustrates that particular problem. The other case, I always, maybe this is a little bit of prejudice on my part, I always do try to put in some state cases because the states do matter, and you can wind up getting appealed into state court as well as you can into federal court. And there are sometimes some quite thoughtful decisions out of the state courts. So there was a New York Supreme Court case in this Paul T. litigation. Kid had apparently been bullied rather badly and has a bit of a reaction to that winds up with the child being taken out of school, or at least subjected to disciplinary action because of that. And the parents contended that the child, in fact, was eligible for special education, relying rather heavily on the idea that the kid was being bullied. And the New York Supreme Court, at least based on the record in front of it, said, well, the key thing is to pay attention to the definitions that are in the IDEA. The mere fact of being bullied may have some relevance to that, but it doesn't determine that the child is eligible. Instead, you have to look to the eligibility criteria, which might be a persuasive sort of a response. Plainly, there are cases that do deal with bullying or what you might characterize as harassment and relate that to special education and special education eligibility. And we'll talk about that in a little bit, but the mere fact of being bullied doesn't constitute a disability. I mentioned a little bit about the additional OSEP letters, or the letters from Department of Ed, and how I think that they often tend to be relevant and need to be paid attention to. So I've got a selection of those dealing with eligibility, evaluation, etc., that are in the materials, to just maybe mention a word about each of them. So the first one is the State Directors of Special Ed, that's on page 2 of the non-PowerPoint of the PDF materials. Key thing there is simply a reiteration that a school district can't deny evaluation or delay evaluation if there is a request for evaluation, but the kid is currently in a response to intervention or RTI type setup. The second one is a Dear Colleague letter. There are obviously dozens upon dozens upon dozens of Dear Colleague letters. The key thing about this one is that there was some concern, particularly with respect to kids displaying signs of autism, that once the kid actually gets the diagnosis of autism, that the kid often will then be moved from a speech-language classification to an autism classification. And there was concern that the child then would no longer be evaluated and no longer get services directly related to speech. And OSEP is simply saying, don't do that. If that could come up in a case that would be in front of you, where the parents might, for example, complain once the autism diagnosis came in and that was the eligibility category, all of a sudden the services or evaluations shifted. That may or may not be appropriate, and OSEP is simply saying that you still do have to pay attention to speech and language issues. The Blogdet letter also is, I think, of interest with regard to eligibility. What they were confronting, this is not exactly related to speech language, but a little bit related to speech language. The kid who, for example, gets a surgical intervention, or, although it usually doesn't have this effect, gets a cochlear implant and all of a sudden now can hear. Is the child now no longer eligible, say, for speech and language services? And I think OSEP is saying what I think most of us would respond. Well, it depends on how quickly the child can then recover from difficulties caused by deficits previously. And the answer to that is maybe yes, maybe no, but OSEP wants to emphasize that possibility that there might be a need for additional services. Finally, I've got a letter Kotler in the outline. That one is essentially just saying that your criteria for visual impairments have to be broad enough to cover kids who'd actually meet the federal definitions with respect to disability. Again, may not be all that critical, but if you do have an eligibility case that deals with a child with a visual impairment, you'd probably want to be aware of the letter. There are some letters as well that have to do directly with independent evaluation. I didn't really see that much in the way of New York or Second Circuit case law dealing much with independent evaluation, although we might be able to pick up one or two instances as we move along. But it struck me that probably the more significant things were in the letters. SAVIT is the first one. It's the thing that probably you've heard of already, that the idea is that IEE, or independent evaluators that the parents arrange, should have the same or at least comparable qualifications to those evaluators who are used by school districts, and if there are criteria, then they should conform to those as well. BAUS is maybe a little more noteworthy than SAVIT. BAUS says that you can have IEEs in different areas that might be required under IDEA. I think the regulation probably would have to be interpreted that way, but the thing is that when IDEA was drafted, I think that the drafters had in mind that there would be a single evaluation, not realizing that typically the evaluation is a whole battery of different things. And so you tend to see the use of these words in the singular when in fact they may really be plural, and I think that BAUS is emphasizing that. And then finally, there's yet another SAVIT letter. I don't know whether Mr. or Ms. SAVIT is particularly big at writing letters for guidance to OSEP, but I thought that it would be useful to put it in as well. This is one that says that if you've got an independent evaluator, that the independent evaluator has to have access to the classroom, even if the school district might in some respects be reluctant or otherwise might not want to do it, but it says that it's part of the right of the independent educational evaluation. If it's necessary to the evaluation to have access to the classroom, the school district is obligated to do it. So that's it really that I wanted to emphasize with regard to child find, evaluation, and other such things. Maybe just to mention a word about evaluation and the like, just as a general matter. I've made the observation before, and those of you who've seen some of the stuff that I've been writing on this probably know this. It has always struck me that because of what might be limits on substantive rights under the Rowley case, parents often tend to emphasize issues such as quality of the evaluation or quality of the IEP or other things that are not exactly appropriate education issues, but things on which they can argue for a stronger level of services, perhaps, than if the decision were entirely focused on issues of Rowley. And in fact, the way that the evaluation and the IEP regulations in statutory terms are written, I think there's some valid support for that idea. But it does, once again, emphasize the importance of evaluation, eligibility determinations, and IEPs, which is what we'll talk about next. So the next topic is this IEP process, IEP implementation, everything related to that. And as I guess I was trying to telegraph a moment ago, there's really quite a bit of development with regard to that. LO is a Second Circuit case, relatively recent. Key thing about this one is simply that you need, if you're the school district, to tie up the evaluations with the services. The parent prevails, arguing largely that the evaluations showed a lot of problems, but the IEP didn't seem to quite match up with the problems. Some decision makers seem to be somewhat more adamant than others with regard to making sure there really is a match between evaluation in all areas of suspected disability and goals and services in all areas of identified need, whereas some other decision makers seem to maybe have a little looser connection between those two. I read LO as requiring a fairly strong connection, saying that if you've got identified areas of need, for example, with regard to behavior, or in this case, the child had problems with regard to PICA needs for physical therapy, then once those areas have been identified in a good evaluation, you then do have to respond to that. So I think that's of some real significance. The TY case is in the outline. I'm not going to mention it now, but the SY case is one that I did put in the PowerPoint and I thought also had some interest to it. Probably the single most interesting thing to it and the thing that would have the most direct bearing on your own decision making is that the court there said that sure, there were a bunch of procedural violations. Many of the procedural violations standing by themselves, however, would not amount to a deprivation of appropriate education of FAPE and really wouldn't have necessarily impeded the parents from exercising their procedural rights. But after then discussing one or two where the court seemed to think that it did have that effect and did justify a remedy, the court comes to the general conclusion that the cumulative effect of various procedural violations that in and of themselves might not have these wider reaching effects have the effect of justifying a remedy. And I thought that was significant. You know, the idea that sure, normally you think of disaggregating procedural violations, but then the court at least thinks that it's important to reaggregate them at the end. It also does emphasize the idea that some of the things, for example, not giving reasons for rejecting a program that had a smaller ratio between the class size and the number of instructors, that the failure to give reasons on that could be a procedural violation that would prejudice the parent's ability to challenge the decision. And I think it may be the first case that I've seen that at least does it in a very clear way. So once again, it might be a case that would be worth your while to look at if you're dealing with the situation of alleged procedural violations, particularly of violations that might have to do with giving reasons or withholding reasons for what the school district is doing. There's yet another case that maybe fits in a little bit with SY. The SY case is a New York City case. The PF case is not New York City, although it's also Southern District of New York. argument here was that the school district had engaged in predetermination and hadn't come up with adequate goals and other kinds of things for the child. But in some ways it looked a little bit like SY because there were a bunch of things that had been identified as needs on the evaluation, but somehow there was a disconnect, according to the court, between what the evaluation seemed to indicate was needed and what the IEP provided. And I thought that was of significance in terms of what's of what a court might be predicted to do in responding to an administrative decision. There's been a big issue, as probably you all are aware if you do any of the New York City cases, with whether the particular school or the particular class that the Department of Education chooses for a child is going to be adequate to fulfill an IEP. It seems from the pattern of cases that typically what New York City does with a kid who has rather severe needs is it identifies sort of general program, but then later on informs the parent of the precise classroom and school. And the parents, in at least a number of contested cases, say, look, we're not necessarily disagreeing with the program, but we don't think this school can implement it. The decisions in those cases strike me as being rather unpredictable and really do seem to go in different directions. In this one, the court said that the parents could in fact rely on what they had observed in visiting the placement for their conclusion that they didn't think it would meet the child's needs. But I cannot say that this is necessarily even representative of what other courts have done. Some other courts have said, no, you need something more than that. Other courts seem to think, oh, maybe you don't even need that. So I do want to leave open the possibility that this may not be fully representative, but I think folks should probably be aware of the idea that the particular placements are subject to challenge and then have to decide for yourself what level of challenge needs to be made for parents to prevail in that kind of a claim. There are a few other cases, all of them, maybe not surprisingly, maybe surprisingly, I'm not sure, dealing with IEPs and IEP implementation and dealing with the New York City Department of Education. MT, I do fear sometimes that I kind of oversample cases that are decided in favor of parents, partly because those are the ones that tend to be a little more groundbreaking sometimes, a little more of a dog bites man character, sometimes are just things that people need to be concerned about, whereas often cases decided in favor of the school district, although they might break new ground, in a large number of instances, they're not necessarily breaking new ground. There is, in this instance, a decision in favor of the school district in MT. Whether it breaks new ground, I'm not absolutely sure, but it's useful, I think, as a contrast to some of the other cases, because there or here, the court is saying, there actually was an adequate connection between what the evaluation identified and what the IEP came up with. There was adequate consideration of the parents' concerns and what the IEP came up with. So I think that that's helpful. It's also, however, a little bit of a contrast with PF because the school district here is arguing that the parents really don't have a ground on which to say that the placement isn't going to be adequate. And the court, for its part, says, well, if you haven't placed the child in the public school that's been recommended, we think that it's most sensible simply to look on the face of the IEP and not then necessarily entertain a challenge to the particular school or the particular class, or at least that you shouldn't allow additional facts garnered after the parent's rejection of the placement as evidence that the placement would not be any good given what services have to be delivered for the IEP. I don't think that every court would agree with that, but it does, I think, present an argument for that position. And in a case that might be in front of you, you might very well be either given this case as an example of where that result ought to be argued, or alternatively, this might be a contrast between one of the other cases and it with respect to that particular issue. There are plenty of other cases dealing with the resources of the school to implement the IEP. SB is yet another one. This is a tuition reimbursement case. The parents visited the school, and the assistant principal told them that, well, you know, you can send your kid here, but frankly, the special ed program is oversubscribed, and we're out of money, and there could be some real problems. As I said, not every court is willing to credit that kind of a rejection ground, but the court here certainly did, and ultimately ruled that the classroom that had been proposed is not sufficient to meet the child's needs. So that's SB. I threw in a couple of additional letters here as well, letters from OSEP. Couple of them I think could be important to your decision making. Not absolutely sure, but you'll have to make that determination yourself. The first one is that OSEP is saying that there is no obligation on the part of the parent to notify the school district before the parent shows up with an attorney at the IEP meeting. So if you're confronted with a situation where the school district is accused of not holding an IEP meeting or of doing something bad at an IEP meeting, and what they say is that the reason is that the parent brought an attorney without warning us, that in and of itself is not a ground for them not holding the hearing or otherwise creating problems. Obviously, that doesn't mean that if the parent shows up with an attorney, the school district is necessarily going to do anything bad. They might very well do everything exactly right, but Andel tries to emphasize that you can't in any respect retaliate or act put out because the attorney shows up. The Dear Colleague letter that I mentioned at the end is something that's, it's a difficult issue for me at least to try to come to grips with. You know, with the No Child Left Behind law in particular, there was this effort to try to impose standards for education generally. Obviously, there have been some political issues with regard to that, but there's always been some effort to try to make sure that state academic standards at least are taken into account, both with regard to special ed kids and with respect to other kids. This one, Dear Colleague letter from 2015, talks about the language that's in the regulations about the same curriculum as for non-disabled children for a kid who's in a mainstream setting to be one that's based on the academic content standards that the state has. Now, the recent ESSA law may in fact give the states still broader discretion to figure out exactly what their standards are, but I can certainly imagine a parent in particular saying, under this Dear Colleague letter, the IEP that this mainstream child has doesn't have a close enough connection to the state academic standards, and then you'd be forced to make a decision whether that is a ground to object to the IEP or not. Want to move on to the next topic, however. Deustedi, did you want to mention here?
Yes, code number 2 is now on your screen. Please write code number 2 on your affirmation form. I'll keep it there for just a few minutes. Mark, I have a few questions that have come in.
Of course.
So I'd like to read those to you, and hopefully to the extent that you can respond, please do so. The first has to do with the first slide, which and ask, would BOUS, letter to BOUS, OSEP letter, support parents' request for IE for a neuropsychological evaluation at school district's expense if the school district refuses to conduct a neuropsychological evaluation? And would that be a procedural deprivation of FAPE?
The short answer, I think, is it would depend on the child's needs. I don't recall in BAUS whether there is a specific mention of psychoevaluation as opposed to other evaluations, although I do believe that there is at least some case law specifically on psychoeducational evaluations that's not New York specific. Certainly the logic, though, of BAUS would suggest that if the child has one of the areas of suspected disability being something that would be picked up in a psychoeducational evaluation, that the child would be entitled to that if the school district has not conducted an adequate one on its own.
Okay. You know, in this case, questions like this always remind me of the dialogue that Lynn and I have going back and forth most of the time in terms of reminding folks that IDEA speaks to an evaluation as a process, not particular assessment. And we should always keep that in mind, because it depending on the question that's before us, that has implications. The next question that I have is, can Mark expand on the distinction he was drawing, and I believe this came up during your second slide, the distinction he is drawing between Rowley-based FAPE challenges and hearings that challenge issues other than denial of FAPE in an effort to expand the range of services or amount called for on an otherwise appropriate IEP. Specifically, is there such a thing as a sufficient impartial hearing request that does not allege a denial of substantive or procedural Rowley appropriateness?
That's an interesting question on which I think my answer would probably be yes, there is, but I can imagine arguments that might go in the other direction as well. To expand on the general idea that I was trying to put forward, in 1997, in the major revisions that were taken on IDEA, the Congress did not do anything to undermine the Rowley standard. On the other hand, what it did do was put into place more specifics with regard to evaluation and a lot more specifics with regard to IEPs. Since that time, at least it's been my observation, that a lot of advocates have tended to focus on the failure to comply with evaluation requirements and the failure to comply with the IEP requirements, and have placed less emphasis on a frontal challenge to appropriate education under a Rowley standard. Now, you can certainly argue that some of those failures to comport with evaluation standards or IEP standards are procedural violations that could deny free appropriate public education because either they frankly just do or because they impede the parent's ability to use the process, which could then seemingly be analyzed apart from specifics of Rowley. We may actually get some guidance on that. It might come in the form of that Andrew case that's still in front of the Supreme Court. It did seem from the reports of the oral argument that the court was grappling with some idea that the Rowley standard, although it may not exactly be obsolete, nevertheless maybe should be given an interpretation that's somewhat more modern, that embodies somewhat different expectations, and perhaps the changes made in 1997 with regard to the things that I was talking about might be used as informing that decision, but heaven only knows. I'm also taking bets for the idea that it will be a 4-4 split with no precedential results, so who knows.
Last question. Given Andel, how can school district guarantee their right to have counsel present if parent has counsel present?
Yeah, and the answer is I don't know. It could create a difficulty. The regulators here say that you cannot condition the holding of the IEP meeting on the parent's attorney not being there. So I don't know what that means, whether you can ask for a delay or whether that in and of itself would be a violation of what OSEP thinks is appropriate. I wish I could give you a clear interpretation on that, but I really can't.
Okay, with that, I'm turning it back over to you, Mark. You can move on to the next slide. Thank you.
Great, okay. So appropriate education is the next thing, and this will then dovetail or mix in a little bit with the next few issues, which will include things like class size, age range, and again, the particular educational placement that's chosen for a child. Wanted to bring in the JD case. You know, this is a case that was decided with a non-precedential opinion from the Second Circuit, and it's always very hard to figure out what to make of those. I'm kind of reminded of that line, I think, from Louis Meyer of Metro-Goldwyn-Mayer, that an oral contract isn't worth the paper it's printed on, or something like that. That may be so for non-precedential, unpublished opinions too, but at least it gives you some sense of maybe what the court might do. You know, it's predictive, if nothing else. So I do feel that if you've got a federal appendix opinion that maybe could have predictive effect, it ought to be flagged, and you all should probably be aware of it. The big thing on this JD one is that the court seemed to emphasize the fact that the child had a program similar to what the public school was proposing that was proposed for the child now after the child had been in a private school. The private school, on the other hand, although it had had the kid only for a relatively short period of time, had suddenly transformed him from a total non-reader, and the kid is now like a preteen, into a kid who can read at the first grade level. It's always been my impression that courts are impressed by nothing like success. You know, if you can actually show, if you're the parent advocate, look, we found something that works here, that I think often can be persuasive. And I have a sort of underlying feeling that that's what was going on with the court. But it does show this idea of appropriate education being informed by what's worked and what has not in the past. The next couple of cases, MB and CR, I'm going to group those together. They're district court cases, both New York City, both Southern District of New York. The big thing on those is that the parents argued that the goals had just been taken from prior IEPs, and that for that reason the IEPs were not adequate and appropriate education was not being provided. I think that was true for a greater degree in the CR case perhaps than in the MB case. But in any instance, the courts said, yeah, but the IEP still looks adequate to us, and if the child didn't meet the IEP goal, but the IEP goal remains appropriate, you really don't have anything to complain about. So think of those cases perhaps as being relevant as well. Oops. Next one is class size and age range. This historically has been a big issue because typically states had rather rigid rules about the distance between kids in age in a classroom and the number of kids in a classroom. Those rules have been relaxed in a lot of places, I think probably because of the influence of greater mainstreaming that's taken kids out of self-contained placements that had these rather rigid limits applied to them. Nevertheless, the courts in a few instances have emphasized the idea that because of disparities among the ages of kids, or because of the, again, larger number of kids in a class, the placement is not appropriate. And so that embraces this LR case. This is one where the parents, I think quite persuasively for the court, presented evidence that the child has very, very difficult problems with being able to focus and maintain attention, and that then justified a smaller class size. That's also, I think, true with the SC case, probably to an even greater degree. So the SC case seems to have this specific evidence with regard to distractibility, and a big debate over whether it's a 12:1:2 for the kids to the teacher to the paraprofessionals, or whether it's an 8:1:1, and the parents ultimately do prevail in front of the court on that issue. The other thing that maybe because I don't want to forget to mention it when we talk about reimbursement. The reimbursement test that the Second Circuit has endorsed, as we all know, emphasizes a lot the idea of equities and whether the parents have engaged in equitable conduct or have not. In this instance, the parents entered into a contract for the private school before the IEP was actually finalized, and so they didn't absolutely know what the school district was offering before making the contract. The court here, however, is rather sympathetic to the parents, saying that, well, they had to do that because otherwise they might have lost the slot in the private school, and so we can't say that their conduct was not equitable or not fair. That's worth noting. If a court has that position, and I can't see any reason that that would necessarily be false, that may be a reason that the court would then require a tuition reimbursement remedy. The JF case is going back to this idea about whether the particular placement is going to be one that can implement the IEP. In this instance, the court says that the objection to the implementation idea, or I guess we could coin a new word of implementability or something like that, was speculative, that they didn't have adequate evidence for that. What's more, and of some significance, and perhaps in line with what I had described as the trend of relaxation with regard to age range, the court here says that a rather wide age range, I think about 3 years, was okay under the circumstances of the case. The next thing are these educational placement decision cases. The ones that I pulled out are basically ones where the parents prevail, but I don't want to give the impression that the parents always prevail if those cases go up to the courts. And in fact, there are some cases in the outline that I'm not going to mention that aren't on the PowerPoint where the school district is successful with regard to a particular educational placement decision. The SY comes back again. Remember, that's the one about how the failure to give reasons is an important procedural violation, and the cumulative procedural violations. Here, once again, one of the problems was that the Department of Ed delayed in notifying the parents of what their actual proposed placement was. And the court places, I thought, a great deal of weight on that in deciding in favor of the parents. Is that predictive of what a court will necessarily do in a case that's appealed, that's one of yours? Heaven only knows, but it's worth noting that in this instance, a court did that. There is, I think, an interesting and to my mind quite open question, and perhaps one in which you can find a conflict of authorities as to who has what kind of a burden with regard to this business of whether the particular school can implement the IEP. I mentioned that one case where the court says, well, you just look to the IEP if the kid hasn't actually been enrolled there. In the WW case, the court seems to think, more or less on the contrary, that at least if there's some question or reason to doubt that the school has the capacity to implement the IEP, then the school district actually has the burden of showing that it can implement the IEP. I'm not sure whether that's an outlier or not, but it's certainly a recent case that maybe ought to be taken into account on that issue. The next case, this FB one, a reason that I wanted to put it in is that before I saw FB and one or two other cases that looked like it, I really wasn't aware of controversies regarding the DIR/floor time method of providing education for kids, particularly with autism spectrum disorders. And at least the way it's portrayed in some of the cases, it appears to be a bit of a, I guess an alternative, you might say, program for kids with autism in contrast to applied behavioral analysis. The interesting thing in the FB case is, at least the way the court framed the case, the private school had been using this DIR floor time methodology, the public school, again, allegedly, was taking the IEP goals that had been used for the floor time process and then placing it into the IEP, but there appeared to be some evidence that the particular placement that they then selected didn't have the ability to implement this DIR floor time program. And so the parents wind up prevailing based on that, or at least it's a little more complicated, I guess I should say. It appeared that perhaps the school could have implemented the DIR floor time, but couldn't do it in the intensity that the IEP seemed to call for. The IEP called for it 5 times a week, and the people who could provide it, it appears, were only available twice a week. And the court thought that that was quite a significant disparity, and the parent ultimately prevailed. SB, again, is that one about oversubscription of the program, so I don't need to belabor that, but it might be helpful to have that in your little file folder if you have one about educational placement decisions. As you probably all know, autism has been a huge issue, particularly in New York, and it's something where, because of the greater identification of kids with autism, you could predict that there would be a larger number of disputes over what appropriate services are in those circumstances. The Second Circuit case of AM is pretty important, I think, with regard to that. AM, you can analyze this, I think, in any number of different ways. It involves a kid who has a need for autism services. The challenge to a what is actually a fairly small student-teacher ratio is not providing sufficient one-on-one ABA type methodology services. Ultimately, the parents prevail here. There's a bunch of procedural stuff that the court, I think, seems not to place a huge amount of emphasis on, but the court does emphasize the idea that there seems to be a disconnect between the evaluations and what winds up on the IEP, and is particularly concerned that the IEP doesn't seem to specify much in the way of methodology, much less specifying this ABA methodology. And ultimately, again, the parents prevail. And there is a quote that I put in the outline that may or may not be of significance, but that I thought deserved some attention, essentially saying, when the reports and evaluative materials present at the CSE, the case study evaluation meeting, yield a clear consensus, an IEP formulated for the child that fails to provide services consistent with that consensus isn't reasonably calculated to enable the child to receive educational benefits, and the state's determination to the contrary, therefore, is entitled to no deference because it's unsupported by the preponderance of the evidence. And it says that remains true whether the issue relates to content, methodology, delivery, instruction in the child's IEP. So once again, at least my reading is the Second Circuit is requiring this tighter connection between what's in the evaluation and what's in the IEP. That's yet another one of these floor time cases. And so I think it recommends itself on that, although the result, as far as I could tell, is maybe a little bit ambiguous, saying that the lower court here should not have relied on a general conclusion, in this instance by the state review officer, that the IEP was sufficient, but saying that what the SRO should then do is ask whether you should match up the goals with the floor time methodology. Let's move on to that WS case. If you're following along on the outline, this is another page or two on. I think it's on page 14 of the PDF. The thing about this one is that the kid had been in a program where he had not done very well and in fact had regressed without one-on-one services. The parents are arguing for one-on-one. Once again, it seemed to me, at least in reading between the lines, that the court was deeply impressed by success or lack of success, and here the fact that the kids seemed to do well with one-on-one services and historically had not done well with group services was the thing that actually decided the case in favor of the parents. Again, whether that's fully predictive, I guess I'm not willing to try to speculate on, but again, it's probably worth noting that nothing succeeds like success in special ed as in so many other things as well. MG is also probably worth noting. This one is, again, not much like a case that you're likely to see in front of you. It's a class action. It's challenging an education department's alleged policy of not providing adequate one-on-one ABA, extended day type services for kids with autism. Anybody, I think, who's followed special ed for any protracted period of time knows that courts have in general been quite hostile to the idea of blanket policies that don't pay enough attention to individual needs, and at least it's the allegation of the parents here, whether they can support it obviously has not been decided yet, but that there is a blanket policy at work that doesn't sufficiently individualize, and the court in this instance grants certification to a class on that issue. The final case that I've got on the slide here is this GB case. This is indicative actually of a few other cases in other jurisdictions, and that's why it caught my eye. The kid here does have autism, but the kid also has a real susceptibility to climate control related things. Apparently there's some medical condition that dries out the kid's breathing, for lack of a better word, apparatus, his nose, mouth, etc. And as a result of that, the kid's highly susceptible to strep. The parents say, you're not providing in the IEP for really any of the kids' medical needs, much less this business about climate control and problems with dehydration and the lack of humidity in the air that will make this kid particularly prone to infections. And the court accepts that argument and says that the program is not sufficient based simply on that proposition. That's what I wanted to emphasize about autism, but again, I do also want to make the point that there are plenty of other cases out there. They really go in all different directions, and these are simply the ones that I thought were most newsworthy in the last couple of years. Extended school year, you know, there's been debate back and forth on this. The consensus of courts, as far as I can tell, is that there's what courts have called a regression recoupment model, that if the kid is particularly likely to lose ground over summer, that's the key consideration to look at with regard to the entitlement to extended year services. Blanket policies forbidding extended year are no good. Maybe that should be met with a, slapping the forehead and saying "do" or something like that. But in any event, the IB case seems to adopt a view that looks like that, although the child here was one who had such a severe cognitive impairment that I think the argument that the child wouldn't be extended or subject to extended year services was rather weak. And the court here does require reimbursement for the parents going out and getting the services. Next topic, this also I think probably could be described as broadly within the idea of appropriate ed, but it's post-secondary transition. And there's been a lot of talk about this as well, partly because the revisions to IDEA in 1997 and in 2004 seem to emphasize more about preparing kids for adult life than some of the language in IDEA previously. Partly, I think, because the baby boom, the kids of kids who are at least of the earlier end of my generation started to go into school and get older. And one thing about them is that the parents, having grown up in a situation where special education services were no longer unusual the way that they were when I was growing up, had higher expectations for their kids, and so started pushing a lot harder for post-secondary transition services to enable the child to do well after the K through 12 period is up. And it is true, and I think probably all of us have encountered families where this is the case, that the parents seem to experience kind of a cliff effect for their kids, where the child seems to be doing well in special education until the end of age eligibility or the end of when the child is receiving secondary education. And then there's really nothing out there, and the parents come back and argue, had the kid been better prepared during K through 12, then the kid would be better able to adapt to adult life and wouldn't be sitting in the basement playing video games 12 hours a day. And so that's an argument that's been made in more than one case. Sometimes that matches back to the argument that we were talking about a moment ago, where the parents say that the evaluation with respect to post-secondary transition or need for services along those lines was not adequate. The IEP is not adequate with respect to that. So therefore, I am entitled to a remedy that addresses that issue. Other times, the parent makes that argument and the court says, well, yeah, but there were still good services that were provided. There's no guarantee of success here. And the MM case is an instance where I think it's more or less that latter sort of proposition. So the IEP did not have much in the way of specifics with regard to the location, duration, frequency of transition services, but the IEP did provide for services, and it appears that services were in fact being delivered, and the school could, based on what was within the IEP, figure out what to do with regard to the vocational and other transitional services. And so the court winds up upholding what the SRO did and upholding what the school district did. As I said, there are plenty of cases out there on this topic. They don't seem mostly to be New York specific cases, but I think it will be an issue that will come up more and more as time goes on, and probably more and more simply as expectations rise with regard to benefits for kids with disabilities. I wanted to take up the topic of peer harassment and bullying. Maybe I'm a little bit prejudiced in favor of this topic by the fact that I wrote a book about disability harassment, but partly because the TK case came down in the last year or so, and it's the Second Circuit's talking about the topic of bullying and harassment and how that might affect special education issues. Folks may remember Judge Weinstein, in a very elaborate opinion back in 2014, said that bullying can be something that should affect a kid's special education program, and that it's something that has to be considered at the IEP meeting if the child's experiencing bullying. The Second Circuit essentially endorses that without endorsing necessarily the other 99 pages of the Weinstein opinion. I do, however, recommend, if you do have the chance, looking at the Weinstein opinion. It's very scholarly and takes up issues with regard to harassment and bullying in a very comprehensive way. What the Second Circuit said with regard to TK was that it was a serious violation of procedural rights for the school district essentially to stonewall, if that's what they did, with respect to bullying if the parents bring that up at the IEP meeting. Some of you may also be aware there's a Third Circuit case that was decided actually by Judge Alito when he was still judge rather than Justice Alito, the PS against Shore case, that is a little different, but I think partly because of what happened with Justice Alito going on to the Supreme Court afterwards, has remained a case that's cited pretty universally throughout the country, where the court says that the nature of bullying can be such that it renders a public school placement not appropriate for a kid. TK doesn't precisely say that because it latches onto this issue about parental participation instead. But I think you can find that in the Weinstein opinion of the lower court, and perhaps the Second Circuit is effectively endorsing an approach of that type. Once again, though, I did want to make sure that you were aware of this Paul T. case from the New York Supreme Court, saying that, yeah, but in and of itself, bullying doesn't constitute a disabling condition or make the kid eligible for special ed. What's next? Well, I always try to include something about related services and assistive technology, partly as a transition to the least restrictive environment issue. I know a few of you I've talked with at various points, and you probably have heard me go on and on and on at length about the relationship that I think is present between related services and least restrictive environment, that the thing that enables kids to succeed in a less restrictive environment is the quality of the services the kid gets there to enable the child to do well in the mainstream. Not every related services case ties up to least restrictive environment, but I try to avoid talking about one without also talking about the other, simply because of what I perceive as being a possible relationship between the two. The one case that I did pull out with regard to related services and put on the outline is the IB one, involving this child who had rather multiple and rather severe disabilities, and the court does go on at some length on the nature and quality of the related services that the child needs. And in this way, it almost disproves my hypothesis. This is a child who the court says is going to need one-on-one instruction rather than a more mainstreamed setting, yet still is entitled to a wide range of related services. So to that extent, I thought was newsworthy in addition to the other cases. But I don't want to neglect the broader topic of least restrictive environment. And I pulled out a couple of cases and put yet another one on the outline without putting it on the PowerPoint here. With regard to this, there's a DN and an HW case. Interesting thing about them is that they are ones that don't necessarily arise out of the city of New York, so that makes it a little bit different from some of the others. Other things of connection with them is that they seem to go perhaps somewhat in opposite directions. Nevertheless, they ultimately both wind up being decided in favor of the parent. So take out of that what you will. The DN case, kid with autism, the child has on the IEP a goal that involves social interactions and having better social interactions with peers. But then the IEP services that are provided essentially look to be one-on-one. The school district says, well, yeah, that's what the IEP says because that's what we wanted to emphasize. But in fact, what we would do would be bring in kids from a somewhat less restrictive setting, an 811 type setting, to interact with this child, so we'd be able to accomplish it that way. What the court says is, well, no, wait a minute. If the RE line of authority, which I think folks are probably familiar with, which says if it's not on the IEP, you can bring in testimony that explains what stuff on the IEP means, but you can't talk about services that are not on the IEP. That's retrospective and isn't going to be considered. The court thought that's what's going on here, that this bringing in of the other kids is not what's on the IEP, so therefore it shouldn't be taken into account. What's more, it does appear that the private placement that the parents wanted did have peer interaction, although of course it's not a public school, so to that extent some might consider it to be a more restrictive environment. But what the court says is what really matters in this instance is peer interaction, and the peer interaction is present in the private placement is not present in the other placement. The kid has the goal of peer interaction, the allegation that there might be peer interaction anyway in the public school we're not going to credit, and so the parents ultimately prevail. HW, I thought, did work a little bit as a contrast because the state review officer decision in this instance actually had approved a program with greater mainstreaming than what the parent actually wanted. The parent argued that the kid had generally done poorly in previous classes that were too large, at least unless the kid actually had a lot in the way of individualized services, and the court accepted the argument that the parent made here, that this would not be an adequate placement for the child. So obviously LRE can go in both directions. On the one hand, you have one where the parent prevails by saying that more social interaction is required, and the other essentially saying less social interaction, I suppose, is required given the specific needs of the kid. What's the next cluster of, before we get to the next cluster of topics, Stady, you might want to...
Yes, code number three, folks, is on your screen right now. Please write code number 3 on your affirmation form in the designated spot, which is labeled code number 3. So code number 3 is on your screen. I will leave it there for just a moment while I read 2 comments that came in. They're not questions. The first was to make a point, and that point was talking about the floor time cases, and that was that there are many cases where the district picked up DIR goes from the Rebecca School. Rebecca School, Mark, is a school based out of New York City that uses the floor time model, the DIR floor time model. Yet public schools have no ability to implement. So the comment here is that the school district is adopting these goals that may very well have been written by the Rebecca School, and then offering a placement in the public school, and the hearing officers emphasizing that, you know, in some cases there isn't the ability to implement them, but the school is using the fact that they've adopted these goals from the Rebecca School and offered a placement in the school as a defense that's saying, you see, we listened to what the private school had to say, and we are accommodating this in our public school.
Oh, that's helpful. Thanks.
And then another point that was made is just worth stressing, and this is regarding the MG case, which is the class action case you mentioned. As reviewed here was, as Mark noted, a grant of class certification, not a substantive determination, and that case continues presently. As it happens, it does so before a different judge. So a hearing officer wanted to share that tidbit with his colleagues.
I appreciate that a great deal. I couldn't find anything reported after that 2016 opinion, so I was wondering whether there might have been a settlement or something in it, but it's interesting to know that it's still pending. And
then one last comment or question that just came in, so I just have to go through it. But NYSCD, New York State Education Department, in making findings on state complaints, has determined that one-on-one paraprofessionals count toward the programmatic paraprofessional ratio, example 12:1:4, 6:1:1, etc. This raises the question of whether state education agencies are required to or should take federal court decisions into consideration in rendering decisions on state complaints. This may be beyond the scope of this presentation.
Wow, that's an interesting issue as well. And that's something I should research, I guess. I don't know the answer.
Okay, and the last is a question, and then I'll let you go on because I know that you have a lot to cover in the limited time that we have. Was RE, retrospective evidence, decided prior to the DN decision that you just reviewed?
I believe the answer to that is yes. And in fact, I did not pick up the RE case because I believe it's 2014, although I could be incorrect on that.
And to your defense as well, is it's something that I mentioned to you that we had covered extensively in prior webinars.
Mm.
All right, so code number 3 is now going to go off the screen. If you haven't written it down, I advise you do so quickly. And Mark, it's all yours.
Okay, so we'll move on to, I guess, page 16 of the, 16 of the PowerPoint, which is behavior services and discipline. Again, folks who might have been exposed to me in the past, and I don't know whether you have or not, I tend to, whenever talking about student discipline related issues, also emphasize the idea of possible entitlements to behavior related services, because if the kid's getting good behavior related services, you might prevent the school discipline issues from ever arising. You might thereby create a situation where there's no need for student discipline. So I'm separating out here then a few additional cases, or cases that we've talked about before, where behavioral services are of particular importance. The LO case we talked about before. Key thing about this one is, at least the way the court views it, the behavior services that the school's willing to offer, the court thought were not adequately based on the particular functional behavior analysis that applied to this kid. Folks may or may not know, functional behavior is pretty much premised on the idea that all the kids' behavior has some kind of function, and if you can figure out what that function is, you can then influence what the child's behavior is. I suppose if you subscribe to a view that a lot of behavior is utterly, totally random and unpredictable, then you might not be all that persuaded by ideas about functional behavioral analysis, but it seems to be the approach that the U.S. Department of Education and really the drafters of IDEA in recent years have taken to heart. The JE case is, again, I wanted to put in some cases where the school district prevails and where not exactly new law is made, but at least the case might stand out a bit. Here, what the court essentially argues is that the behavior intervention program, although not perfect in terms of controlling all of the child's behavior, was adequate, that it did a good enough job, and that even though it was not completely updated over various periods of time, it was certainly good enough, and it's what the child did need. I did note that there's an appeal that's been filed on it. I haven't seen what's happened to that since the middle of last summer, so I don't know whether that's still pending or not, but I presume it is because Westlaw indicates that it is. There's also a Dear Colleague letter. This is, I think, kind of illuminating. It's talking about the idea that if there is chronic misbehavior, that's a strong indication of a need for behavioral support. I mean, again, that may be kind of the duh hypothesis, but it probably is worth noting that the U.S. Department of Education is emphasizing that idea. Certainly, we've all encountered a situation and perhaps even felt that way ourselves, that, well, what it really is an indication of a kid who's really engaging in a lot of bad behavior. But what the regulators here are trying to say is that, well, in that instance, you have to check to see what behavioral supports the kid is getting. The student discipline specific thing that I put in was the one to Snyder, and this could be quite significant for you all. What it basically says is that there's no authority to extend timelines on an expedited due process hearing. There is no provision in the Part B regulations that would give a hearing officer conducting an expedited due process hearing the authority to extend the timeline for issuing the determination at the request of a party to the expedited hearing. They do say that you could bifurcate expedited and non-expedited issues, so that's a possibility, but it seems to be rather adamant otherwise. What about due process complaints? There's a variety of stuff here, and it's hard to say too much without getting so deeply into the weeds of particular cases that I fear I might lose my audience here. But what I can say is that there are some judges who seem to say that a fairly strict reading of a due process complaint and the exclusion of issues that are not raised on the complaint is a perfectly valid approach, and that it was right for the impartial hearing officer to have not proceeded on issues that were not mentioned or developed in the complaint. And the MB case, the first one on the list there, is an example of that. The CWL case is a good example of that. Contrasting with that, the HW case, here the case actually had a kitchen sink worth of issues. The question was whether the kids' entitlement to one-on-one services was sufficiently raised by the complaint. What the court says is that, well, it certainly wasn't the focus of the complaint, but it was mentioned. And the regulation, the statute, doesn't require that the complaint has to focus on a given issue for that issue to be relevant at hearing. As long as it's in there somewhere, apparently, that's good enough. And, you know, it's, I think, hard to take exception to that reading. So HW may be of significance with regard to that. You know, back to the Rebecca School here. So the JW one is whether the complaint was sufficient with respect to raising of this DIR issue. The court seemed to think that the DIR issue was sufficiently raised. The parents, though, ultimately do not prevail on the argument that what would have happened is that the school district would have done nothing but ABA. So the parents do not win, but the idea that the complaint should be read in a somewhat broader way winds up nevertheless getting supported. So what's the next topic? Again, those of you who know me know that I tend to obsess a bit on settlement issues simply because so darn many cases are settled. And working in a law school, I can tell you that the law school curriculum prepares students quite badly, in my humble view, for dealing with settlement-related issues. So I try to make up for that single-handedly by emphasizing things having to do with settlement when making presentations. What things are significant in that regard recently? Well, there's actually a U.S. Supreme Court case, not involving special ed at all, but that does relate to settlement and could be important, I think. Somewhat oddball case, uncertified class action. The defendant essentially offers the plaintiff everything that the named plaintiff would be entitled to and perhaps something more, then says, well, because we've offered everything that the named plaintiff wants, the case is now moot, and you can't get any further relief in the case. The Supreme Court, with Justice Ginsburg sounding very much like the civil procedure professor that she used to be, says, well, no, that's not correct. In fact, an unaccepted offer of settlement is a legal nullity. And if the named plaintiff in this class action or any other plaintiff in any other action doesn't accept the offer, the case is still live. Now, she did hedge the bets a little bit, seemed to open up the idea that if the defendant actually admitted liability and put amounts in escrow, or at least deposited them with the court, that might be a different case. But I think probably every hearing officer, I expect, who's done a range of cases, has confronted a situation in which the school district has offered what appears to be the services that the kid is entitled to, and then says that the case is moot, and the parents are reluctant to accept that, sometimes because of attorney fees issues or because of issues with regard to ongoing relief or just something else. And it's interesting to have a U.S. Supreme Court opinion that says, well, until it's accepted, it's not accepted, and it really doesn't exist. The other case that's of significance, this is a Dervishi case. It's the particular opinion that I'm looking at here is actually the F appendix opinion in the case. The issue here was whether the settlement that had been reached in the case established, there are ongoing issues, established a stay put placement for the kid during the pendency of the rest of the dispute. And the lower court seems to think not, and the Court of Appeals seems to say yes. Although, frankly, there's there are some ambiguities in what I was able to read with respect to the lower court opinion. So I'm not sure that I want to state without qualification that the lower court opinion was necessarily of a different approach than what the Court of Appeals was. But the idea that the settlement could create a stay put placement is of importance, and that's what the admittedly non-precedential Second Circuit opinion seems to be saying. The letter to Cohn, I also put out there. This is, again, of importance, I think. It's commonplace, I believe, or well known anyway, that for mediation, the statements of the parties are viewed as confidential under the federal special ed law. There's no such language with regard to resolution sessions. And the Cohn letter says, so therefore it's not confidential. Now, I think an argument can be made, and I've said this in a couple of other forums, that, well, that may be so, but under Federal Rule 4 and most state laws that I'm aware of anyway, or state evidence codes that I'm aware of, nevertheless, statements made during settlement negotiations may be viewed as being excludable, as not relevant to the case, or as otherwise being things that you want to encourage, so therefore excluding them from evidence is desirable. But I think what the federal regulators here, to be fair to them, were saying, yeah, but that isn't what's actually embodied in the statute here. If you want to exclude evidence based on other considerations, based on your interpretation of state evidence law or federal evidence law, that's something else again. They don't opine on that topic at all. Let's talk for a moment about everyone's favorite due process hearing limitations. I try to avoid using the word limitation for anything but statute of limitations for fear of confusing my vulnerable students. Here, limitations is being used precisely for that term. And what we've got is my old friend Perry Zerkel once again trying to get guidance out of the federal regulators as to whether it was the Department of Ed's view that the GL case controls with respect to at least the situation directly in front of it, whether compensatory education would be governed by what approach to the statute of limitations. And I figured folks probably should be aware that the Department of Education essentially punted on that issue, saying they're continuing to deliberate whether it's meaningful or not. And I understand that you folks have had some discussion in previous trainings about GL, so I don't want to belabor GL. Obviously, it's a Third Circuit opinion. It will no doubt affect different courts' views of the scope of compensatory education, but I think it's a little unpredictable precisely how it's going to do that. Probably near and dear to everybody's heart is the topic of just what it is the scope of the due process hearing ought to be and how it is you conduct the due process hearing. So I thought I would bring in as much as I could on that topic, particularly things that originate in the courts of, or the Court of Appeals, directly relevant to what it is you're talking about. The MO case seems to have gotten a lot of attention from the lower courts, and probably with good cause. It's one where the school district prevails, but the court gives a little more guidance with respect to, I think, possibly the meaning of RE, but also to that issue that we flagged previously about the ability of the particular chosen school to implement an IEP. And as I say in the description that's in the PDF, I think you can take this to the bank on the proposition that the Second Circuit believes that parents they can make a prospective challenge to whether the placement school can implement the IEP, that the kid doesn't actually have to get enrolled in the school and then fail for the parents to make that kind of a challenge. And of course, some of the district court cases that we looked at were ones that precisely were parents prevailing on challenges of that type. The kicker, though, is that the court said after making that statement, but that isn't really the case here. Instead, the case here looks to us to be more of a challenge to the IEP itself, saying that it wasn't adequate, and frankly, we don't see that. The court there seemed to be upholding the IEP on basic grounds of adequacy. So it's important, I think, to be an indication of what it is the Second Circuit thinks would be covered, but it also is a case that, as with many, many others, says what the school district is offering on the IEP is an adequate, appropriate education. What other things? Well, this JE case rejects a claim of bias on the part of a non-attorney impartial hearing officer who happened to have been the former state superintendent of schools. Also, there was an allegation made by the parents that the IHO here was not paying attention and, in fact, was sleeping during parts of the hearing, and the court said the record does not support that, and winds up upholding the decision there. This case too is on appeal, however, so we will see what happens with it. The JC case, I think, might be a little bit predictable, maybe not, I don't know. So the kicker on this one is that the hearing officer, and I've seen this done in some instances, although it certainly is not universal. It seems that frankly, some U.S. District Court judges, as well as some hearing officers, adopt a procedure that's comparable to the one that's frequently used in federal administrative proceedings and in state administrative proceedings that relate to things like utility pricing, where what they do is, for the direct testimony of either all or some of the witnesses, they say bring that in by affidavit. Will enable you to cross-examine the witnesses live, but it'll save a lot of time if we effectively get the testimony in writing with respect to direct. The hearing officer here appears to have done that, but set a deadline for when the affidavits would be due, then changed the date of hearing to advance that date that the hearing would take place without changing the due date for the affidavits, and then excluded affidavits that weren't filed sufficiently before the hearing actually taking place, but that were filed in accordance with the original order giving the deadline for when you had to file the affidavits. And the court says, no, you can't do that. That if you modify your order for when it is affidavits have to be filed, you have to do that with adequate notice and presumably in written form to the parties so that they don't get treated badly as a result of that. I don't see an appeal on that one, so I think that's a final decision. There are a few decisions that have generally to do with things like timeliness, and the HB one is maybe not all that remarkable. There are a few opinions here and there, and there's language in the legislative history of the 1986 amendments to IDEA saying that a protracted delay may in some circumstances be a ground on which to excuse exhaustion of administrative remedies. But the Southern District of New York here said, yeah, but not here. It in fact maybe opened up the idea that there wouldn't be any such exception. And in fact, there's a non-presidential affirmance of that view. In this instance, there did seem to be various grounds on which the state, for lack of a better party to put the responsibility on, really was trying very hard to get the case decided in a timely fashion, and everything seemed to conspire against that happening. The Walsh v. King case is one where the parents basically want to get the placement that they want instated because of the delay in the hearing decision, or actually I think in this instance perhaps the SRO decision. And the court doesn't do that, but what it does do is enjoin the decision making to say that there ought to be that saying that the state review officer has to issue the decision within 14 days. So that's timeliness. Maybe it isn't too illuminating, but it does give you a little bit of something there. So the next one is this Rye case, and I debated a little bit whether to put this one in or not. I don't know that it actually breaks new ground on the law. It's one where the school district seems to prevail on an issue related to the quality and nature of services on the IEP. There's a bit of an argument with respect to the retrospectiveness, if that's a word, of the testimony and the ability of whether psychological services are going to be provided. The reason that I think it deserves attention is that the district court really called out the impartial hearing officer for what the district court, and I did not look at the underlying decision, so I'm not making any characterization of my own here, describes as rambling, incoherent, contradictory, and incomplete written decision. For that reason, of course, the court says we should instead defer to the SRO decision, which the court thought was thoughtful and comprehensive. But obviously, everybody wants to avoid getting criticized by a district court judge for having a decision that doesn't make sense. So it's probably a cautionary tale, if nothing else. Once again, though, I don't want to say that the district court was necessarily right. All that I want to say is that obviously you should be concerned about it. You know, as we all know, oh, wait a minute, before I go on to that, we got yet another announcement.
Folks, thanks. On your screen right now is code number 4. Code number 4 is on your screen. Please write it down in the designated spot on your affirmation form. Code number 4 is on your screen. Please write it down on your affirmation form. Just going to leave it up there for just a few seconds. Mark, there are no questions or comments at this point.
That's probably good because we're running a little low on time. Yep. So yeah, it might make sense for me to speed things up a little bit. Yep. But
so code number 4 is on your screen. 3, 2, 1. Mark, take it over.
Okay, good. So next, I just had I don't want to belabor this one at all, but I did want to throw in a couple of cases where the reviewing court says, yeah, in general, we defer to the SRO decision, but frankly, in this situation, the IHO decision was better thought out, better written. And so that's the SY case, that's the SB case. The JE case is a little bit different. So the parents screwed up procedurally on some issues about filing the appeal of the independent hearing or impartial hearing officer decision. And the court basically says, look, the SRO took the appeal anyway and decided it, so it's properly in front of the court now without there being a valid objection based on exhaustion. Oops, well, here I'm going to go back to state level appeals, maintenance of placement. Next topic is maintenance of placement. I wanted to make sure that people were aware of this Doe against East Lyme case. It covers a lot of various ground, but what's important here is that the court requires reimbursement of services that the parent acquired during the stay put period, but the school district did not provide. The court requires reimbursement even though it appears the parent didn't actually spend the money but had the unpaid bills that the parent hadn't been paying. It also says that even though the services that the parent provided unilaterally were in some respects not appropriate and so weren't entitled to reimbursement as a matter of the decision as a whole, the kid could in that circumstance be entitled to compensatory ed. And I think that's of significance. I've seen a few courts that seem to have not considered that possibility. The Dervishi case comes back again here. Once again, we're talking about reimbursement for services that were in line with the settlement, which the court thought was the stay put placement. And then the AW case fits in here as well. Here, the parent argued that the impartial hearing officer decision established a stay put placement by agreeing with the parent. The decision of the SRO undid that decision, and it was the district court's opinion here that it was then the SRO decision that prevailed, and you can't count the decision of the impartial hearing officer as establishing a stay put placement once it gets undone in this fashion. What's next? Standards of review. I thought I would just throw in the AM case because it is a Second Circuit case with a full opinion, and it's one that says, yeah, in some circumstances you should defer to the independent hearing officer rather than to the state review officer. Everybody's favorite topic from civil procedure, if nothing else, is preclusion, of course. Luo is one of relatively few cases on this topic. There's a case called Pace against Bogalusa out of the Fifth Circuit, but there aren't a whole lot of others. This one is simply saying that the parents may be precluded by collateral estoppel on an issue with respect to reliance on an evaluation. If you wind up with a parent or a school district arguing preclusion, either collateral estoppel or res judicata or something, you probably need to look at this case. So take a look at it, even though it's actually a federal appendix opinion rather than a full F3rd opinion. So what issues have been present here with regard to tuition reimbursement? Well, some of these things we've already kind of covered. I thought I would throw in AM simply because it's a relatively recent reiteration of the test for reimbursement about the defendant has to establish that the student's IEP actually provided the free appropriate public education. If not, the parents would be entitled to reimbursement if they establish, number 2, that the unilateral placement was appropriate, and 3, the equities favor them. In the MW case, it said that previously. A bunch of other cases have said that, but it's a recent reiteration of it. The issue about whether the parent's placement is good enough has come up in any number of cases. Hardison is an example where the court says that it wasn't good enough to meet appropriate education, deferring to the state review officer on that proposition. I think Doe against East Lyme, in significant part, is a case that says that as well, and so it's important with respect to that. AW, maybe Doe against East Lyme effectively establishes this anyway, but it's one where the parent would otherwise prevail on reimbursement. The school district says, yeah, but in fact the parent hasn't paid anything. And it appears that the private school, has at least waived collection of the amounts, although the parent remains obligated. And the court says if the parent's obligated, even if they haven't paid, they're entitled to the reimbursement. So that is of significance as well. SC, I thought I would remind people of that one. Again, this is the one where the court says that the equities are met even though the parent signed the contract before they got the IEP. And so to that extent, that arguably premature action didn't swing the equities the other way. I thought I would throw in at least one case with respect to related services reimbursement, and that would be this Doe against East Lyme one, although that's a little bit of a peculiar one because the related services were ones pursuant to a stay put order. The LK case is maybe a little bit more significant, even though it's only a district court decision as opposed to a Court of Appeals decision. It does wind up, at least in significant part, winding up being affirmed by the Second Circuit in a non-precedential opinion. What it suggests is that you can reduce reimbursement for related services on equitable grounds. On the other hand, the Court of Appeals decision says, yeah, but also the parents may be entitled to reimbursement for services that were not covered under the pendency order that is at least principally at issue in the remainder of the case. So whether that works a modification of No against East Lyme, I kind of doubt, but it does suggest, on the one hand, that if the costs are unreasonable, they can be knocked down. But it also suggests, yeah, but you got to look at that kind of carefully to see what services are actually the kid is actually entitled to. One thing that the Second Circuit did say in the non-precedential part of the opinion is that if you're considering knocking down the reimbursement, you do have to consider where it is you are, and things might be a lot more expensive. Services might be more expensive in New York City than they might be in some other parts of the state. I always, in any presentation, try to throw in at least something about kids in juvenile detention. Hanbury is this long-running litigation in New York about services for kids in juvenile detention. The 2015 opinion that I cite here is one that enters an injunction for services for kids in jail, seems to set essentially a minimum of 3 hours of services a school day for kids, which I thought was a little bit unique. The Dear Colleague letter emphasizes a lot of things that other guidance out of OSEP and OSERS have said before, that yeah, you do have to provide services for education of kids with disabilities in correctional facilities if the kids meet the eligibility standards, and it goes on at rather extreme length on precisely what that has to constitute. I've only cut out a sentence and put it in the PDF, but if you do wind up with a case that has anything to do with correctional facilities, by all means take a look at that letter. Well, where does that leave us? It leaves us with a bit of additional time, in which what I'd like to do, if you're willing to indulge me, is maybe just mention a word or two about some cases from other than the Second Circuit, other than state courts of New York or the district courts of New York, that struck me anyway as being things that you as New York hearing officers nevertheless ought to at least be aware of as being somewhere on the radar screen. And the first and probably most obvious one is simply this Andrew case that's in front of the Supreme Court, already was argued, that's talking about appropriate education about FAPE and what the duty there entails. And obviously what the parent is arguing is something that's been bandied about throughout the Court of Appeals, that on the one hand, changes that have been made to the statute since Rowley came down in 1982 really have changed the content of free, appropriate public education. That argument, I think, has some challenges to it. You know, obviously the Supreme Court has said in other contexts that when Congress wants to overrule a Supreme Court decision, by and large, you know, it makes it quite clear that that's what it's doing, and that does not in any clear way appear to be the case in this instance. Nevertheless, from the reports of the oral argument, it appeared that the Supreme Court was at least amenable to the proposition that the Rowley standard might, perhaps in some respects, not in others, be obsolete or at least subject to modification. And as folks know, Rowley itself has a built-in ambiguity to it. You know, on the one hand, it talks about a basic floor of services, talks about minimal access. On the other hand, also does talk about the idea of meaningful services. And you can pick out language that does use, that kind of language. And it could be that what we'll see is the Supreme Court taking that language and taking the caveat that the Supreme Court did put in, and that most other courts have pretty much disregarded, that we're only talking about this kid's case in this particular context of a child who's in a mainstream setting and doing well for our determination of what appropriate education constitutes. So obviously, unless you've been really under a rock, you probably know all about this, so probably I didn't need to go on at length with respect to it, but I did want to flag it. The other case that probably folks know about from the Supreme Court is the Fry case, which dealt with exhaustion. But I didn't put it on the outline because simply administrative exhaustion, typically is not really your issue. And although I thought it was going to be possible that what the court would do would be give a little bit of guidance as to how Section 504 and IDEA interact substantively, whether there's an informing of FAPE based on Section 504 or ADA concepts. The court does not appear to have confronted that at all. And so although they say you don't have to exhaust under the approach that the Sixth Circuit used, this case about whether Wonder the service dog is going to be in the public schools, it does appear that there really isn't any guidance with respect to just what, if anything, the ADA does for public schools in distinction or in connection with the IDEA obligations. What other cases might you want to have on your radar screen a little bit? Well, I thought that Timothy O., although it's out of the Ninth Circuit, maybe was worth looking at, partly simply because of its facts and partly because it looked a little bit like cases I've seen in other jurisdictions that got kind of similar reactions from courts. So here the argument is that the child should have been evaluated for autism a lot earlier than the child was. Parent relied on some evidence of autism that showed up with respect to the kid early on. The reason that the school district didn't evaluate the kid for autism is that the staff member who was observing the initial evaluation of the kid said, yeah, but this kid just isn't acting autistic. I kind of know it when I see it, and without the behaviors that I think of as characteristic of autism, it makes sense to limit the evaluation to other factors, notably speech and language and other such things. And the court says that's no good, that you can't just rely on an informal observation in determining that the child is not going to be formally evaluated for a condition if there is evidence that the child has the condition. So they're reading literally the language from the statute and the regulations about the child being evaluated in all areas of suspected disability and taking that seriously. The other thing about it, and this is also a little bit typical of other cases I've seen throughout the country, the school district argues that it was okay for them effectively to delegate the evaluation to another public entity. And the court doesn't really say that you can't do that, but it says that if you do that, you've got to make sure that that evaluation comports with IDEA standards. And I think that's of significance as well. So it's really a case that spells out more about evaluation than what I've seen out of the local cases that you folks need to be familiar with in the last couple of years. And so for that reason, I thought deserved a little bit of attention. I threw in the Seth B. case with respect to independent evaluation as well. This is one, I mentioned the fact of the independent evaluation regulation requiring that the independent evaluator essentially conform to the standards for evaluation that the school district is bound by. The difficulty is that, of course, there may not be precise compliance with every aspect of what that might be. And, there's an interesting sort of policy dilemma here, I suppose. I can imagine parents, for example, pushing very hard for the idea that there'd be a lot of requirements on the evaluators that a school district uses, and then kind of getting hoisted in their own petard if the independent evaluator that they choose then winds up getting disqualified for failing to meet those standards. What the Fifth Circuit in the Seth B case says is, well, yeah, we understand exactly what the regulation says, but we think that for an independent evaluation, if what you have is substantial compliance, that's good enough. They also, interestingly, upheld a cap on the amount of reimbursement, although they seem to say that that was being done because the parent didn't come in with anything particularized saying that the cap was too low given the specifics of this kid's condition. The LJ case, I really, really, really wanted to make sure I mentioned, even though, again, it's out of jurisdiction, partly because it simply contrasts so extremely, in my view, with that very first case on the outline, the RE against Brewster case. So RE against Brewster seems to say, no, the kid's not eligible for special ed because with the Section 504 type accommodations and the like, the kid seems to be doing okay. The LJ case says almost the opposite. It says, yeah, the kid seems to be doing okay with all of these accommodations that are being made, but frankly, we think that those accommodations, even though they're not being provided under IDEA, meet the IDEA definition of special education. So therefore, the kid is in need of special education, has the disabling condition, and therefore is eligible. So I'll leave you to decide which of those is the more persuasive, but it certainly is as big a contrast as I've ever seen on that issue between the views of two different courts. Doe, I thought I'd also flag a little bit because it's a dyslexia type case, a learning disability case, and although the kid has some strengths that enable the kid actually to test pretty well on reading, there were other drawbacks as well, and the court, I guess, emphasizing this idea once again about assessment in all areas and services in all areas of identified need, emphasizes the idea that the kid is eligible because of the specific deficit with regard to one aspect of reading that winds up being deficient. What about compensatory education? Well, I threw in a couple of cases on that because obviously it's a big issue and one in which you might be inclined, if you so choose, to look to out of district precedent, in part because that's where things are going. With regard to the MS case, the big deal on this is that the 10th Circuit opines that it's not proper to delegate to the IEP committee, the CSE committee, in your instance, what the compensatory services that the kid is entitled to as a result of the due process hearing decision. That's, I think, kind of a big deal. I mean, they have various reasons why that is, but I've seen plenty of instances where hearing officers and courts have done that. So you might want to look at the opinion if you are so inclined to make that sort of an order. And then finally, I thought I would include this Boos case. Yes, it's also DC Circuit, so again, it's not in any way binding, but it stands for the proposition, which to my mind is kind of self-evident, that if it's compensatory education, that's something above and beyond what is appropriate education for the kid, given the kid's condition. I mean, there'd always been an issue with regard to comp ed, whether you need something more than just what appropriate ed is, and the court here says yes. So that's basically it for the out-of-state stuff, and we're then on to Dave Stady.
All right, code number 5 is on your screen. Code number 5 is on your screen. Please write code number 5 on your affirmation form. One thing to clarify, Mark, and again, fidelity to the decisions, what you were reading from the decision, the AM case restates an error that is found in RE, and that has to do with the allocation of the burden of proof in New York. Under New York law, the school district has the burden of proof on the two of the three steps of the tuition reimbursement remedy. The school district has to demonstrate that it provided a free, appropriate public education and that equities does not favor reimbursement to the parent. The parent has the burden to demonstrate that their unilateral placement is appropriate. RE misstates that, and AM seems to pick up on that mistake. So I just wanted to clarify that what you were discussing on AM is an error that is found in RE under the Second Circuit's decision, but that New York State law is quite clear as to who has the burden of proof. And
do you think the court might actually modify AM based on that?
It didn't do it on RE.
Interesting. Yeah.
And it sits out there. And given the number of tuition reimbursement cases in New York, you would think that they would, but yeah. I can't speak to that. Folks, it's 8 o'clock, and I want to thank you for your participation today. I want to thank Mark for this presentation, a quite informative presentation, a lot of cases. I know the last time we did an update was back in almost 2 years ago, so Mark had a big task ahead of himself to present all the cases that have come in the last 2 years. Our next webinar is on May 4th, Thursday, May 4th, so we look forward to your participation. Have a good night. Send me your affirmation forms, and I will acknowledge them in due course. Thank you, Mark, and all a good night.
Oh, thank you all, and thanks for all of your attention.